Interestingly, no lawyer was ready to argue the right-based case for all the animals. Even the consultant of World Wildlife Fund Pakistan was not willing to go to that extent. Their report also focused on improving the conditions within the zoo for the inmates. So what to do? All these inmates, as far as I was concerned, they had rights. They could not be deprived of their natural habitats, and that was a very, very crucial right that everyone had. How to enforce that right? So, the first thing that I did was to survey the jurisprudence from the other jurisdictions. The jurisprudence was very, very interesting. Like, for instance, in Argentina, only to the extent of chimpanzees, the rights were to some extent indirectly recognized, but they were on the basis of the attributes which they shared with humans. So again, it was in the context of humans. In India, they interpreted their right to life of the Constitution under Article 21 and declared that even the bulls, you see in this case, enjoyed the same rights. But subsequently, the Indian Supreme Court has overturned that judgment. In the United States, it was even more interesting. It was interesting because in the United States, the petitions were filed seeking the writ of habeas corpus, and it was for an elephant, Happy, who is still an inmate of the Bronx Zoo. Professor Stephen Wise, who passed away this year, I must acknowledge his contribution because he was the one who was pursuing the case of Happy. The Supreme Court, the New York Supreme Court, and then its appellate court, the judges were very, very sympathetic. They were sympathetic. They said very nice things about Happy, about elephants, how important it was. But then you see, they would come to the conclusion that Happy or any other non-human species was not a person, and only a person could be granted the writ of habeas corpus. Recently, when I was at the New York bar, the chief judge, who had also rendered a judgment on Happy, he said something very interesting in his speech. He said that he and I shared one thing, that both of us have authored judgments in cases of elephants, but that he could not succeed while Pakistani court did succeed in implementing its judgment. So, we have, after surveying all the judgments, I came to the conclusion that all the constitutions have been drafted and promulgated by humans to organize themselves, to govern themselves. They are not in the context of life other than human life. So I realized that that was the confusion. That is why even our constitution is only focused on the rights of humans. That is why a person as defined in our constitution is restricted to a human. Though even our constitution protects or guarantees the right to life. But that right to life is only and only restricted to a human. So what, and this is how you see the jurisprudence that I had laid. That what is the difference between a life of a human and a non-human? It's this attribute, life, which creates a right. A right exists when a thing has an intrinsic value, and that is to be protected. And I'll go back to the fundamental principle of preservation of life. That also emanates from the same concept. So, the jurisprudence that was evolved, and the reason why it was declared by the Islamabad High Court that every non-human species has natural rights, was based on this very premise, that it is the attribute of life that gives existence to rights. And what are those rights? And I've also explained it in my judgment, that the inmates of the Islamabad Zoo, they don't seek the same rights as humans. Even an elephant or a monkey, they would not have the same rights, but every non-human has a right to enjoy its natural habitat. No non-human can be deprived of its habitat. And if this right is accepted, the looming threat of climate change can be dealt with effectively. If the habitats are protected, if the biodiversity, the fauna, flora automatically gets protected. And it's, again you see, it wasn't just rendering this judgment. There was then very strong opposition. And surprisingly, the opposition came from the Ministry of Climate Change, the federal government, and they filed a review. The review also had to be dismissed. And they had no reason. They had no ground for the review. It was probably more of a problem of ego. Because I declared shifting of all the inmates within Marghazar Zoo to their natural habitats. Kavan had to go to Cambodia. The two bears to a sanctuary in Jordan. The monkeys who were natives of Margala Hills and Margala Forest were imprisoned within their own natural habitat. They had to be set free. Many birds had to be set free. It has never happened. The most difficult task for the court was to ensure that its judgment is implemented. Because if a court cannot implement its judgment, it undermines the very existence of that court. But I must acknowledge the role played by Mr. Amir Khalil, Dr. Amir Khalil, who's here with us today, his organization. And it was at this stage that the renowned singer of United States, Shirley, she stepped in. She offered to pay the expenses because it was a very, very expensive, costly exercise to shift Kavan from Pakistan to Cambodia. She also decided to visit Pakistan, and that is what changed the decision of the government of Pakistan. They also realized that internationally it has gone as a huge credit to Pakistan and its people for evolving a jurisprudence which was first of its kind internationally. The only other jurisdiction other than Pakistan where the rights of animal species or non-human species have been explicitly recognized is Ecuador. But again, Ecuador Constitutional Court had the advantage that their constitution provides for a constitutional right relating to protection of nature. Pakistan was and still is the first jurisdiction